matters in person and pro se. This matter was last before the court on July 18th. It was continued to today's date. I think that the question still before the court is whether to adopt Mr. Mosier's request that this essentially be dismissed, or the DCF position concerning the fixing of child support in line with their motion and worksheet. Uh, I know that there has been some discussion of these matters. I'm more familiar with them, having reviewed some of the, I believe, most relevant documentation in the court file. Ms. Hawks, can you just summarize afresh for the court why you think the court should uh, follow your motion and impose a support amount?
Your Honor, the parties entered into a agreed parenting plan. Trying to pull that up now. And I believe it placed the children with mother, with father to have visitation. So DCF filed the motion to establish, basing it off of the child support worksheet that was filed January 28th of 2025, which showed a guideline amount of $952. When we were last here at hearing, father kind of alluded to that the parties were actually utilizing more of a shared parenting time versus him just having every other weekend. So we continued this matter for father to be able to file any appropriate motions to get that order modified to reflect a 50-50, but I don't see that anything has been filed at this time, Your Honor.
All right. Mr. Mosier, do you have any updates for us, sir?
I don't have any updates as far as because I didn't file anything. I wasn't asked to file anything. I've kind of just been telling you what's been going on. And that's kind of how the conversation went the last time. Now, as far as I guess my question is, why would the DCF do this? Okay, because of the insurance that the kids have through the state. Well, they have insurance through me. And I spoke to Sherry after our last court hearing, and I asked her, because she signed the document, and the reason we went with the document that we went with was because she wouldn't sign off on anything less than what was in that document, essentially trying to get out of the court system. We had been doing this for 4 years. We'd both already spent money on lawyers, the whole 9 yards. And then the day that this was signed over to you and the DCF was the day that he signed in the piece of paper, which is our parenting plan. At that time, I had not gotten insurance for them. I had not done anything because we were still going off the old parenting plan. Now, since then, they have insurance. And now Laura has moved in with me. Now I could start filing a bunch of stuff and we could bring this back in the court system, but neither Sherry and I want to. And that's what I asked her. I said, look, I'll need you to come to court and either testify that Laura's living with me and we'll have to start changing things, or you need to cancel your benefits to the DCF. So they have no stake in the deal, which she said, well, don't the kids have insurance through you? I said, yes. And she decided, okay, I will cancel the benefits. Now she doesn't have any reason to do anything. And this isn't important to her. She doesn't have to show up for court every time. I do. And that's kind of the nature of our relationship. So I would still be requesting that the court drop this. And if the DCF has issue, I think it's an issue with Sherry. From what she told me, she has received the updated, so they send in basically a renewal of the benefits. She said she never filled anything out or turned them in. So I don't know if they automatically redo those based on the old information, or if there's some kind of something that needs to happen with the new information. But I think the issue's more with that than with this document between us, because as far as I'm concerned, that's already settled. What we choose to do with the document is, I don't see how that's a DCF issue.
Well, and I think you might have hit the nail on the head. If there are some benefits being received, it could become a DCF issue. But if you're saying that, as far as you know, the only benefits in question were insurance matters, and if you're further alleging that all of the insurance matters are being handled by you through your own employer, then, or directly out of pocket, I think that information might be relevant for DCF to be able to consider what they might wish to do going forward. Have you provided the insurance proofs to DCF from your employer?
Is that what they would need?
Well, I can't speak for them, but I'm just trying to hear what you're saying, and I'm trying to connect the dots a little bit to wonder if it's purely an insurance question, if you have proof that they're being insured through you, that provision of that proof to DCF might influence what they think would be appropriate going forward.
I don't know how that works per se. I don't know how I could influence a case with the DCF that my name isn't on, aside from which I had considered filing fraudulent, that it was all fraudulent because she was receiving. But to keep the peace between us, I've kept it strictly to the court case, and that's the other reason why I haven't gotten a lawyer, taken it back to court over this daughter who's living with me and the changes in what we're doing. The problem with doing all that, Judge, is I end up back in the courtroom with a lawyer and she ends up back in the courtroom. And this is 4 years later and our kids are growing up and we're spending tons of money on lawyers. It's already been resolved. The only issue is this loose end, and I can't pull her into the courtroom. Um, but I know that, I know you've been doing this a long time. If she was hard off for this, she would show up already. It's been 4 years. She thinks it's all resolved.
Well, and I too understand how you and she could take that position. I've certainly made no ruling on your request that the matter be dismissed, but I'm just trying to, based on what you were sharing today, wonder, and I guess I might ask you, Ms. Hawks, is there any potential benefit to you in terms of considering how you wish to go forward with this case if there could be provision of insurance information, or
DCF asserts control, citing federal mandate to proceed.
even you say one of the children is now living with you, that update as well?
Your Honor, at this point, I'm ready to move forward with child support. I understand everything Father is saying, but at the end of the day, we have an assignment of rights. And whether or not it's just health insurance really isn't relevant when somebody files an application with our office and asks us to establish. And so that can either happen by filing an application or getting on state services. We maintain that assignment of rights until it is severed by that party. And I have no reason to believe that Ms. Mosier has called in and withdrawn any assignment of rights. And before she could do that, any mandatory services would have to be ended. So until that point, DCF stays in the case. And we have a federal mandate to establish child support in our cases. So, I mean, we were here before because Mr. Mosier says the one child is living with him. I understand he doesn't want to go back into court, but he signed an agreement that mother has sole legal custody and he only has parenting time for a few hours every other Sunday. And so those are very different statements, and all I can do is go off of what's in the court file. The real, and I guess I should back up. He's been given the opportunity. That was what was discussed at the last hearing, is that if he believed he should receive adjustments for parenting time, that he needed to file the appropriate paperwork, and he has failed to do so. So the really the only sticking point I see here is if Mr. Mosier believes he's providing health insurance and should receive an adjustment for that on the child support worksheet. I mean, that would be per the guidelines to give him that adjustment, but it's his responsibility to provide DCF with that information, and he has not. So, I mean, it's my position that we move forward with child support at this time, because based on the record, the children are living with mother, father's having parenting time every other Sunday, and our assignment of rights is still valid.
I think that we've had a handful of these today, and I thought I would have long since gotten past saying this is an unusual set of circumstances, but I think this is likewise, to some degree at least, an unusual set of circumstances. And I do think that it is unfortunate that in ways that would be potentially meaningful to him, Mr. Mosier is asking about the availability of the other parent to respond to what he's saying is the nature of their conversations. And she hasn't been here the last two hearings. It won't take long, but I'm going to go off the record for a second and just review the file. I'll be back as quickly as I can. Sorry to take a little time to review this. This is pretty interesting to the extent that, as has been pointed out by Mr. Mosier, the proposed parenting plan, as it was at that point notated, was filed basically 15, 16 months ago, and was made an order adopting the proposed parenting plan just in March of this year. That plan did indeed quantify that neither party would pay support and that they would be using a shared expense plan as was outlined in the agreement. That particular portion of the agreement did leave room for modification of child support if there were failures to adhere to the methodology of the shared expense plan. And it's also noteworthy that the judge's order adopting the parenting plan also directed the parties to exchange information and provide information to DCF with the expectation there would be preparation of a child support worksheet. And these are, like I say, several things coming into focus, and at roughly the same time that DCF was entering the case and was seeking the establishment of child support, a medical support order, and the authorization of an income withholding order. I do think that there is a reasonable question about how the court should proceed as this case and the facts therein intersect the shared expense plan that was adopted in just March of this year. But I also think there's a order that the child support worksheet be prepared. And I do think that at minimum, Mr. Mosier, if he's paying insurance, should get credit for that. And if one of the children is living full-time with him, that should also be subject to factoring in of the worksheet. And so from my perspective, I'm intending to continue this one more time to give Mr. Mosier, to the extent he wishes to do so, opportunity to update the DCF with respect to those particularized facts. And certainly, if there's any additional information concerning adherence to the shared expense plan that is deemed to be relevant, that can be included as well. And I think it's also important to consider the DCF perspective on this and their responsibility and the apparent current reality,
He offers father one last chance to bring proof before ruling.
at least, that there are still services, benefits being provided, and which are being made for the benefit of the children in the case. So I think that I'd like to give Mr. Mosier that opportunity to provide further information if he wishes to do so. But I would like to push through to a decision. And if I don't adopt Mr. Mosier's methodology of dismissing the matter, I will try to fix support, but I would like to do so through the prism of any sorts of credits that he should be receiving based on what he's explaining today. But I think Mr. Mosier, Ms. Hawks would probably need written documentation to be able to reasonably factor that in. I know this has already gone on for a little while, and I don't want it to go on too long. And with that in mind, I was hoping to set this for November 7. Ms. Hawks, do you have any reason why that date would not work on your calendar?
That'll work for the state, Your Honor.
Okay. Mr. Mosier, does November 7 at 3:30 in the afternoon, sorry, at 3 o'clock in the afternoon work on your calendar?
Yes.
All right. Well, I'll continue it to that date and we'll try to get through to a decision that day and leaving everyone in a position to move on at that point. And I'm keeping the request for dismissal under advisement pending that following hearing. And
Your
if there's
Honor.
nothing further, yes, ma'am.
I just wanted to point out that we did discuss that shared expense plan at the last hearing, and that the Bradley software does not allow for a shared expense formula when you're not doing shared parenting time, and that would be something the court could take into consideration and maybe make a overall financial adjustment condition. But the Bradley software will not allow me to do shared
Okay.
expense in
All
this
right. Well,
situation.
thank you, and I appreciate that. And but that's why I was hoping at least there could be a little bit more formal information about what exactly is happening to the extent the court may wish to consider the way forward that is within the court's authority, even if it doesn't jibe completely with what the Bradley software is able to do.
Thank you.
Thank you. Thank you, Mr. Mosier.
Judge,
Yes, sir.
what information do you need and how do I submit that? That's where the cutoff is. I'm not understanding what it is I need to do exactly.
If you have information concerning the amount of money you're spending on insurance, particularly for the children, you may include that and you can send that to DCF. Certainly, if you have information that would corroborate that your daughter, I think you said Laura, was staying with you, if you could write that and send that to DCF. When she started living with you, is she living with you full time? All of the factors that you think are important. And then, as far as the shared expense is concerned, council has indicated that the software that she's using, which is the commonly used software to make these calculations, is not able to countenance the situation where there are shared expenses without shared custody. And with that in mind, if you have factors that you think are relevant for the court to consider, I'm willing to consider those, but I would like you to just write those in some sort of log fashion or in a short form fashion, and also provide a copy of that to DCF just so they'll know what you're going to be asking the court to consider.
Can I address the DCF here?
Sure.
Where do I send that exactly? Do you have like information where I can email or where I would need to go to send that?
Do you have any of the pleadings we've sent you?
Um,
Notice a hearing, anything?
the order granted for continuance, I got it sitting right here in front of me.
So up in the top left-hand corner should be my name, and there should an address. There should be an email address, kslegal@ywcss.com. You can send it to that.
Say that again. Okay, no, I see it here at the bottom. Okay, and I have one other question for you. So as far as this assignment of rights, if she was to call you, and would that be another option?
If she chooses to withdraw her assignment of rights, then yes, and close any mandatory programs,
Okay.
then we would remove ourselves from the case.
Okay. All right, I will work on both of these things and I'll try to get you as much information as possible. Thank you, and thank you, Your Honor.
Thank you. Have a good rest of your day.
Yep. Bye.
Key moment. Clear instructions and a path to resolve emerge. DCF confirms mother's withdrawal could end their role entirely. All right, guys, that's the wrap. Don't forget to like this video, subscribe to the channel, and we'll see you in the next one.